Here's a very common scene. You have a business move that makes perfect sense. It's commercially clear, it's strategically timed, and your team is fully aligned and ready to go. And then your legal reviews it. And legal says no. Or let's take even a more sophisticated version, which is somehow worse. Your legal says, this is risky, delivered in a tone that implies only a reckless person would proceed, followed by a memo, a long one. Everything slows down. And now you have a different kind of problem. Not a market problem, not a product problem, an internal one, with two sides that are both entirely convinced they are the adult in the room. I am Maria Boicova-Wynants, and this is What Would You Do? This episode is about one of the most recurring and least productively resolved tensions in business. What happens when the people responsible for protecting you are the ones slowing you down? Spoiler alert, the answer is not ignore legal, but it's also not defer to legal. Both of those exits from the actual problem. And the actual problem is far more interesting and much more solvable than either side usually admits. When legal says no, organizations do one of two things, and both are failures. And I want to be precise about why. The first one, they override legal. They decide the lawyers are being overcautious, which they sometimes are, and they proceed anyway, treating the legal input as nothing more than just a bureaucratic obstacle rather than actual information. This is what gets called moving fast in cultures that celebrate it. What it actually is unmanaged risk, often held by people who didn't fully read the memo and who won't be in the room when the consequences arrive. The second is they defer to legal. They treat legal says no as the end of conversation. The move doesn't happen. The momentum stalls. The window may close. And the company gets very good at not doing things, which is a skill, but it's not the one that you're trying to build. Here's what both of these responses have in common. They treat the legal input as the final answer. Either you accept the answer or you reject it. And that framing is the mistake. Because legal advice is not a decision. It's an input to one. And inputs need to be interrogated, not just accepted or dismissed. There's also a third failure mode that doesn't get named often enough. A sort of half move. The company proceeds, but cautiously, hedging, doing enough to say they moved, but not actually capture the opportunity. This is probably the worst outcome of the three. You pay the exposure cost of acting and you fail to capture the commercial upside of acting decisively. So you get the downside of both choices and the benefit of neither. Half moving is what happens when the legal business tension is never actually resolved, just managed around until no one is fully committed to anything. Let me explain what's structurally happening in this conflict, because understanding it changes how you resolve it. Legal counsel and business leadership are not disagreeing about facts. They're simply optimizing for different objectives with different time horizons and different definitions of what that outcome means. Legal is optimizing for risk avoidance in scenarios that are often low probability but high consequence, such as a lawsuit, a regulatory action, reputational event, all those. Their job is to surface those scenarios clearly and protect the organization from them. They're very good at finding the way something can go wrong. That's not the flaw, that's what they're for. Business is optimizing for opportunity capture within a window that is often shorter than the legal process assumes. Their job is to move, to compete, to take calculated risks in pursuit of the outcomes that justify the exposure. They're very good at finding the reasons something is worth doing. And that's also not the flow. That's also what they're for. The problem is not that these two functions exist, is that organizations rarely build the interface between them properly. Legal advice is typically delivered as a sort of a verdict. This is risky. This is not recommended. This exposes you to X. That's appropriate for legal opinion. It's not appropriate as the final input to a business decision because it leaves out everything that the business needs to weigh against the risk. The competitive cost of not moving, the window that closes if you delay, the strategic value of being first, the signal that inaction sends to the market. When legal delivers a verdict and business receives it as a veto, the conversation is over before the actual decision has started. The real conversation, the one that produces good decisions, is about trade-offs. And trade-offs require both sides to put their variables on the same table at the same time, with the same willingness to have their assumptions challenged. That conversation almost never happens naturally. It has to be designed. When this tension gets unresolved, when it keeps on cycling through the same arguments without landing on a decision, three things get eroded. And the first of them is strategic initiative. Every time a business move gets stalled by legal friction that isn't properly resolved, the organization learns something. Moving is harder than it's worth. That lesson accumulates. Teams stop proposing moves that will generate friction. Risk appetite narrows, not because the organization made a deliberate choice to be more conservative, but because the path of least resistance is incrementally, invisibly narrowed. The ambition gets managed down before it ever reaches the room. The second is the relationship between legal and business, which in most organizations should be one of the most productive relationships in the building, and in many organizations is one of the most adversarial. When legal is experienced as an obstacle rather than a resource, business teams stop bringing legal in early. They bring them in late when the decision is mostly made and legal has two options: to bless it or to create a crisis. Neither serves anyone well. The adversarial dynamic is self-reinforcing, and the cost is paid in every decision that gets made without proper risk input. The third one is accountability. When business overrides legal and something goes wrong, the legal team was ignored. When legal blocks a move and the opportunity is missed, the lawyers were too conservative. Nobody owns the outcome. Nobody learns from it. And the next version of the same conflict plays out on the same terms, with the same dynamic, just a few months later. The absence of a shared decision framework doesn't just produce bad individual decisions. It produces an organization that doesn't get better at deciding. So what would I do? First of all, I would change the question being asked of legal immediately before anything else. The standard question is, Can we do this? But that question invites a binary answer. And legal, whose job is to surface risk, will default to caution when the question is binary. The binary framing almost guarantees a no, or not recommended, which functions as a no. The question that opens the actual conversation is, under what conditions could we do this? That question doesn't ask legal to approve or to reject. It asks them to map the risk landscape. And that's a question they're very well equipped to answer. It produces scenarios instead of verdicts. If we structure it this way, exposure is X. If we adjust this element, exposure drops to Y. If we phase it differently, the timeline risk changes. If we include, for example, this contractual protection, then the downside is bounded. And now you have the options, not just the wall. Second, I would make the business cost of not moving explicit and put it in the same room as the legal cost of moving. This sounds obvious, but it almost never happens in reality. Legal presents the risk of proceeding, but nobody formally presents the cost of not proceeding. And this asymmetry, it's structural. The risks of action are documented, analyzed, and given to decision makers in writing. But risks of inaction are left to implication. I would change that. For every legal concern presented, I would require a corresponding business impact assessment. What does delay cost us specifically in terms of market position, competitive timing, partner confidence, investor narrative? Doesn't matter what's the actual framing, but not a rhetorical counter to the legal concern, as a genuine input that belongs in the same analysis. When both sides of the trade-off are visible, the decision becomes ownable. When only one side is visible, you get either paralysis or you have recklessness, depending on which side has the louder voice that day. Third, I would designate a decision owner, one person with explicit authority, whose job is to weigh the legal input against the business context and make a call. Not legal, not the business lead, someone who holds both, who understands both, and is accountable for the outcome of the decision, not just their contributions to the analysis. In many organizations, this role defaults to the CEO or a senior executive who gets pulled in to break ties. That works, but it's frequently inefficient, and it doesn't build organizational capability. A better solution would be a standing protocol that defines who owns the decision when legal and business conflict, what information they need to make it, and how that decision gets documented and reviewed. Because the thing about recurring conflicts is that they reveal a structural gap. If legal and business are regularly in tension without resolution, the organization doesn't have a decision problem. What it has is the architecture problem, if you will. And the solution is also architecture, not more meetings. Fourth, I would insist on scenario decisions, not just those binary ones. The choice is almost never do this or don't do this. It's almost always a set of variants. Do this now with these mitigations, or do this in 60 days with these structural adjustments, or do a partial version of this while the rest is reviewed. The scenario approach makes the risk-reward trade-off visible at each variant. It gives decision makers something that they can actually compare. And it gives legal a more useful role not as a gatekeeper who says yes or no, but as an architect who says, here's how each path changes your exposure. That role suits legal counsel much better, and it produces much better decisions. Legal advice that conflicts with business strategy is not a problem to be resolved by deciding who's right. Both are right, and that's the whole point. Legal is right that the risk exists. Business is right that the opportunity exists. And the decision that needs to be made is not which side wins. It's how do we capture as much of the opportunity as possible while managing as much of the risk as it's actually manageable? That's a different question. It's a harder one. And it requires both sides to give up the comfort of their respective positions and do something less satisfying, but much more useful. Think together. The companies that do this well are not the ones where legal and business never disagree. They are the ones where disagreement is productive, where it surfaces trade-offs instead of generating standoffs, where the tension between protection and momentum is treated as useful information rather than a problem to be won. So the next time legal says no, don't override it, but also don't defer to it. Interrogate it. Ask what must be true for the answer to be different. Ask what the no is actually protecting against and whether that protection is worth what it costs. Ask whether there is a version of the move that changes the risk profile enough to change the answer. Because legal says no is a starting point, not a conclusion. And if you treat it as a conclusion, you haven't let legal protect you. You've let legal decide for you. And those are very different things. This interface between legal and business strategy is where I spend a significant amount of my time. Not so much adjudicating between them, but building the framework that makes their disagreements productive rather than recursive. Because in my experience, when this dynamic is stuck, it's rarely because lawyers are too conservative or that the business team is too reckless. It's simply because nobody has designed the conversation that actually resolves it. That design is available, it just needs to be built deliberately. My name is Maria Boicova-Wynants. Thank you for listening to What Would You Do? In the next episode, I'd like to address the following curious question. What would you do if you've already invested too much to stop? Because sometimes the pressure doesn't come from the outside. It comes from the inside. From all the weights of everything you've already committed to, everything that's already been spent, everything that would have to be written off if you now changed course. That pressure has a name. It has a mechanism. And it distorts decisions in ways that are very hard to see from inside. And we are going there next. Until then, think clearly, decide better.